Ask an attorney. Just give him a call.
This is Ask an Attorney, all about Florida law with attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Good morning. Welcome to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. The law office is open. Open just for you, by the way. If you have a legal question, would love to help you. All you need to do is to call a number. And your question can be about wills, trust, probate, guardianship, power of attorneys, family law, real estate law, personal injury law, on-the-job problems, next-door neighbor problems. Hey, you have a problem of any type. It doesn't really have to be a legal question. If I can help you, I'd be glad to. The law office is open at 877-943-9673. That's 877-943-9673. If I can help you in any way, I'd be more than glad to try to do so, get you at least pointed in the right direction. If I don't know the answer, hey, I'll let you know I don't know. But we have plenty of resources. We have plenty of other attorneys that have been on the show as guests. And somehow or another, we'll come up with an answer for you and get you pointed in the right direction. Again, I'm attorney Joe Pippen, host of Ask an Attorney, all about Florida law since 1984. The longest running continual program in Florida, as far as I know. Then every week on the radio somewhere, usually on multiple stations, actually, doing the same thing, Ask an Attorney. It's a live show. I can't prepare for it because I don't know what you're going to ask me. I don't know what you're going to say. I don't know what your situation is. But I'm here to try to help. And if I can, again, phone lines are open. You listen on multiple stations all over Florida. In fact, you're probably listening on, some of you are listening on laptops in faraway places. Actually, you can hear this show anywhere in the world, I think, if you were connected. If you want to call in, no matter where it is 877-943-9673, 877-943-9673. Well, let me share with you a little bit about what happened this week with me. I really had the opportunity of a lifetime, I think. I don't think very many attorneys get to do this, but let me just tell you about it and you can decide that. Flew to Memphis, Tennessee on Monday night. I was at the St. Jude's Hospital on Tuesday morning for a special presentation, and I was honored to be able to give from one of my clients who had died through their trust documents, their living trust document, a $1 million check to St. Jude's Hospital. The young man, he was 55, he died one morning going out for a cup of coffee, had a heart attack and died. He was a professional golfer. He had played in 3 U.S. Opens, played in multiple other tournaments, and he passed away a little earlier than expected, but he had done a very good job on getting his estate plan done. And I fortunately was able to help him do that, just like I'm fortunate to help any of you, regardless of the size of your estate. The size of the estate really doesn't matter. The average gift to St. Jude's Hospital is $40. And a lot of the high upper people at St. Jude's Hospital were there. It was really a special occasion. The PGA Tour had sent in cameras to film the whole thing. St. Jude's has a big golf event in June, and so they're going to re-televise part of the taped. They came in to film the whole thing, and they're going to replay part of that in June at the golf tournament as that's televised. So we put that on Facebook and other places to post it, mainly as a encouragement to others to give to their charities and churches and so forth. You can easily do that in the estate plan. It does make a big difference. It does make a very big difference in other people's lives. So I was very, very fortunate to be able to be involved in that. So I wanted to share that little story with you. Let's go to our first caller. Let's go to Jim in Atlantic Beach.
Hi, Joe. Thanks for taking my call.
Hey.
Hey, I'm thinking about buying liability umbrella insurance, and for that amount, I'm wondering, is my personal residence and my retirement funds, are they exempt from a target for a lawsuit if something bad happens?
Yeah, Florida Statute 222 has a list of exemptions of what creditors cannot take from you.
Uh-huh.
So your homestead is an exempt asset that creditors can't touch. Your retirement accounts, IRAs, 401ks are also exempt.
Okay, very good.
But liability insurance on an umbrella policy over top your current home is a very good idea. It's very good planning. So I would, and it's not really that expensive as I'm sure you've discovered as you're shopping around for it. But I would encourage anyone to do that.
Okay, great. Hey, thanks for your help.
Yeah, Atlantic Beach, how's it today over there? Is it
it's rainy.
Rainy? Okay.
Yeah.
Yeah, I'll be up that way. We have an office in Jacksonville area, so I'll be up that way next week for a little bit. So always look forward to going there. It's a great area. So we stay in the Ponte Vedra area, actually.
Yeah, that's nice, too.
All right, thanks.
Thanks.
All right. Let's go to Karen in Maryland. Hey,
Hi,
Karen.
Joe.
How are you?
How are you? I'm doing well. How about yourself?
Doing great.
I have a friend who is in Manatee County in jail waiting to go to trial, and also has an open case in Charlotte County. And Charlotte County is denying to transport him to close out that detainer. So I'm trying to figure out what case law he could use to have Charlotte County transport him to close out that open case.
Well, I have another attorney friend actually that's on the show. He was a former prosecutor in the state of Florida. Now he's has his independent practice. He does criminal law, is one of his practice areas. I'd be sure if you want to email me, I'll be glad to give you his contact information.
Okay, that would be great. And your email?
Joe, Joe, at attypip.com.
Okay.
Are you listening on your computer this morning?
I'm actually listening on my cell phone.
Cell phone? Okay. Yeah, I've lived in Maryland for 11 years. I went to the University of Baltimore Law School actually at night. So I'm very familiar with all that area. Lived in the Severna Park area. So
very nice area.
Yeah. Yeah, we lived pretty close to the mouth of the Severn River when we lived there. So
that's where Tony Braxton was from too.
Oh, okay. Well, I enjoyed my time in Maryland, so lived there for 11 years. I worked at Western Electric there in Dundalk for a while, and then I went to night law school, and in 1980 we came down to Florida. So,
well, that's nice. I think what you're doing is great to offer advice to people that are in need, and I just happened across this radio station and I absolutely love it.
Well, great. Well, thank you so much.
Thank you.
All right. You're listening to Ask an Attorney, all about Florida law. If you have a legal question, hey, I'm here to help you this morning. And I've been doing this since 1984. Love to come in and help as many people as I can in the hour that we have, or 52 minutes, actually. If you listen often, you know it's a 52-minute straight run. No commercial interruptions. And all of those are played at the end of the show. And that's the way I like to do radio, not to be interrupted as I'm helping people. Let's go to Kay in Avon Park.
Morning.
Hey, Kay, how are you?
Hi. If a tree on my property falls on another person's property and damages either their house, their yard, anything of theirs, am I liable?
Generally not. And I don't think that's a very good law, actually. I think not you, but I think people should be responsible for their trees that do damages to other people's property. But generally, if your tree falls like during a hurricane or a storm, I mean, if you cut it down yourself and it fell over there, you'd be responsible. But absent that, the tree just falls in a natural way through a storm or something, you are not, the person's own insurance is responsible, basically.
Okay. That's what I had understood, but like you say, if you cut the tree and it falls, then you're liable. But if the lightning strikes or the wind blows, you are not actually liable, correct?
Correct.
Well, thank you very much.
Now, let me tell you, I had a tree. I had a big, tall pine tree.
Yes.
Right on the property line, fall into my neighbor's tree. So the tree was, hadn't totally fallen to the ground. It was kind of at an angle into the tree. I felt responsible. I mean, I didn't want my neighbor to have to pay for my tree that fell into his tree. So I called my tree guy and I had it removed. I think that was being a really good neighbor on my part.
Right.
Or at least, at least go share the cost.
Yes.
I had another neighbor where his tree fell into my house during the hurricane this year. It just fell into the back house. It was minimal damage. But it cost me like $500 just to have the tree removed and hauled away. And the neighbor said, hey, he wasn't an attorney, but he started quoting me the law on this and telling me it's my problem. So, I mean, I would call that person a very bad neighbor.
Yes. Well,
but, I think the law is basically wherever it falls, the person's responsible for cleaning up their own mess legally. I think sometimes a good neighbor, on at least some circumstances, it'd be nice for a neighbor to offer to pay for it or pay for half of it anyway.
right. Well, that's what I had heard, and I just wanted to check before I either told someone else or if someone asked me.
All right.
I appreciate it. Have a good day.
All right. You too. Bye-bye. All right, let's go to Shirley in Bradenton.
Hi.
Hey, Shirley.
Good morning.
Good morning.
Thank you for taking my call. I have named 2 family trust executors. Does Florida require that they both have to sign the checks to pay for the estate expenses?
Well, you've named 2 people to be co, or you've named one first and one as a backup?
No, they're 2 to be co. They're both sisters, but they live far away. Do they both have to sign the checks?
Okay, so here's the way I draft trust. I can't answer your question probably. I didn't draft this particular trust, right?
I beg your pardon?
I didn't draft this particular trust you're asking me about.
Correct.
Okay. Well, I can only answer it as if I had prepared it, because it's governed by the clauses and the language in the 4 corners of the document. The way I draft these documents in my trust has a paragraph called authorized signatories. And what an authorized signatory is, if the bank allows for one person to sign on a check, even they're the co-trustees, you can authorize that one person to sign checks. So basically, I think it depends on whether the trust co-trustees generally mean, like on real estate and stocks, they would both have to sign. But if there's a particular account that could be set up and the bank allows an unauthorized signatory for one of them to sign, that would be allowed. So I know I've told you a lot of information there, but basically it depends on whether that clause is in the trust or not. If it was in my trust, I'd say yes, that could be arranged. If it's in a trust I haven't seen, then I can't answer it.
Okay, thank you.
All right, thank you.
Bye-bye.
You're listening to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. The law office is open. We have some open lines right now. If you want to call the show, I'd love to talk to you at 877-943-9673. Phone lines are open. Let's go to Marie in Plant City.
Good morning.
Hey, good morning.
I have a question. My mother recently passed away in Denton, Texas, and she was living with my sister, and there are 4 siblings that live in Florida, which is where my mother lived for almost 60 years and then went to Texas.
How long was she in Texas?
7 years.
Okay.
And so the 4 siblings here in Florida, there was kind of like a family feud because we didn't want Mom to have to go to Texas. And so my sister doesn't really give us too much information, and I'm pretty sure she's got power of attorney. But we're wondering how we can get a copy of our mother's will. We know she passed away in Denton, Texas, and the funeral was here in Florida, but we just want to know, is that a public record? Do we go through that county to try to get a copy of her will, or we don't know an attorney's name in Texas or anything, and that sister isn't talking to any of us, so we're just wondering.
All right, let me relate this to Florida, because I don't know Texas law.
Okay.
And assuming it's somewhat similar, but, I don't know.
Okay.
In Florida, there's a statute that says if you're in possession of a deceased person's will, you have 10 days to file that will. Then it becomes a public record. Once it becomes a public record, then anyone can go down to the courthouse and buy it for basically $1 a page.
Okay.
Or you can view it. You can view it at. They have a little viewing area of wills in Florida, at least in the courthouse in Pinellas, where you can just go look at the will without buying it.
Gotcha. Okay.
So what I would recommend you do is to call the clerk of the probate court in the county she died.
Okay.
Inquire. Usually they'll tell you whether there was a will filed.
Okay.
And they'll tell you the charge it would be per page.
Okay.
Now, if you are a beneficiary named in the will,
I don't know.
well, no, if you were.
Okay.
And if the will was filed and if a probate proceeding was started in Florida, you would get a copy of the will at some point, because the personal representative who hires the attorney in Florida will be supervising the personal representative on what to do, and usually sometimes do it for them and send all of the beneficiaries a copy of the will, and sooner or later would send them an inventory of the estate and how their share was calculated.
Oh, okay. Good.
So,
all right.
But now if you call the probate clerk in the county in Texas and the will has not been filed, and you're pretty sure you know who has possession of it, then that person should get a letter. Well, maybe you'd have to have a Texas attorney help you, but if there's a similar statute in Texas where the will has to be filed in 10 days and the person hasn't filed it, then you hire an attorney to write them a letter, demanding that the will be filed in a timely manner. And if they're holding it and don't file it in Florida, then they could be held in contempt of court, for not filing it.
Okay. All right. That is very, very helpful. Thank you so much, and thank you for your program.
All right. My pleasure.
Great.
My
Thank
pleasure.
You. Bye.
All right. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen. If you have a legal question, you have a toll-free number, 877-943-9673. Phone lines are open. Let's go to John in Orlando.
Hey, how are you? Exactly 1 week ago, I signed up for auto insurance with a company. I decided not to take the vehicle. They put the binder payment of $219 on my debit card. I can't get the money back. For some reason, they say that I have to show proof that I didn't take the car. Is that correct?
Well, you can cancel insurance even if you buy it, even if you didn't have the car. So I don't understand why they're saying.
They're saying it's a Florida law that I have to prove that I didn't take possession of the vehicle. I find that really strange. Whether it's a dealership or private owner, how am I supposed to prove a negative?
Who are you buying the car from?
Well, it was going to be from a private owner.
Well, listen, you can fight with him, I guess, or you can maybe go get an affidavit signed by the private owner that I did not deliver the car, have it notarized, and give that to him. That would be proof.
I shouldn't have to go to that.
I know. But you're not getting your money back. So I'm saying the easiest, quickest way, instead of fighting with them and spending more time and effort on it, is just go get the all the previous owner has to do is sign an affidavit. I did not deliver the car to you, to John, and have it notarized. I mean, you get your money back. If you want to fight, you want to hire an attorney to fight with them, or go take them to small claims court, you're going to spend more than the money that you expended on the down payment on the insurance.
Yeah, I mean, I should be able to cancel at any time.
Yeah, well, it's an economic question also as a legal question. The economic question is, do you want to spend the time and effort to fight with them, or just get a simple affidavit notarized?
Okay, thank you.
All right. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen. Phone lines are open right now if you want to call in the show at 877-943-9673. 877-943-9673. Wanted to tell you this week I had another interesting experience. I was asked to speak at a lunch and learn. I do lots of speaking engagements, and I really love doing them. There's no fee or anything. If you have a group that needs a speaker, I speak at Chamber of Commerce meetings. I speak at business meetings, Rotary, Kiwanis, service clubs, church groups. Speak at a lot of churches. Several of the stations have a Christian format. Here you're listening to 90.3 FM out of Haines City, Florida. You're listening to 579.10. You're listening to other stations that basically have a conservative format, although there's a classic rock station up in Crystal River that carries the show. But anyway, I'm asked to speak a lot. I enjoy it this week. This week I was speaking at a corporate business called Mainsail, and they have a lunch and learn program. So we had two segments. We had two half an hour from 12 to 12:30 and 12:30 to 1. Two different groups came in. I gave a short presentation. This particular case was on estate planning, and they were able to learn during a lunch and learn, and asked me questions, and I gave them all my poster sheet and so forth, and answered their questions. It was a lot of fun. Actually, enjoyed doing that. If you would like a speaker for your group, all you have to do to arrange that is to call our toll-free office number, 1-800-226-3529, 1-800-226-3529, extension 200, and be more than glad to come to your group, give a presentation. Hey, the presentation can be from 20 minutes to an hour probably. It's not really a set talk. We kind of cater it to what you need. We can do the topic that you need and change things up a little bit. So again, the toll-free number for that. The toll-free number to my office as well. We have 20 office locations around Florida. There's no charge for first appointments, no charge for the speaking engagements. 1-800 is their office number, 1-800-226-3529, extension 200. Let's go to George in Jacksonville.
Yes, good morning.
Hey, George.
I have a question that I've been told that you don't need to set up a trust as long as you have all of your assets co-owned or jointly owned. Is that true?
Well, George, let me ask you this. Do you own a home?
Yes, I do.
And who's it?
It's in both of our names.
Okay, husband and wife?
Yes.
Well, if you both die, or upon the second death, there would be a probate of the home.
Okay.
So if you have a living trust, you can put your home in the trust, you can put your joint accounts with your spouse in the trust, and upon the second death, there'd be no probate, quick and easy to be able to pass those things along to an heir. So the answer to your question would be there'd be no probate upon the first death with jointly held assets between husband and wife. But there would be probate upon the second death, and also if a husband and wife do their planning together, then there's much less of a burden upon the surviving one to have to deal with the estate plan because you both did it while you were both living.
I see.
I deal with a lot of guys, George, that basically have the attitude that they're going to die first, so there's no probate, so let the wife handle it after they die. Yeah, but that's a very tough time for a spouse. A couple of years, a lot of times they don't do anything for a couple of years regarding their own death. And they're in depression and their life has changed dramatically, so they don't get to it. So I always tell them, do yourselves a favor as a couple, get the planning done while you both are living, and then there's a lot less burden on the survivor at the time of the first death.
Right. Okay, well, that answers my question. Thank you very much.
All right, thank you. All right, for those of you that would like my free estate planning poster sheet, and you're thinking about doing some estate planning, this is a large poster sheet, double-sided, so let me mail it to you. It's also on my website, but let me mail it to you. It'd be a much more useful sheet for you. I'd love to mail it to you. It's absolutely free. You can get it one of three ways. You can call our toll-free office number, give them your name and address, and ask for the poster sheet, estate planning poster sheet. 1-800-226-3529, extension 200, 1-800-226-3529, extension 200. You can email me your name and address at Joe, at ATTYPIP.com. That's Joe, Joe, at ATTYPIP.com. You can text me for it, your name and address, to 727-667-3967. All right, let's go to Glenn in Bradenton.
Good morning, Joe. Thanks for taking my call.
Glad to talk to you. What can I do for you?
Well, I'll give you a quick brief, and then I have a legal question at the end. But we have an HOA accused over the years of selective enforcement and also issuing variances without hardships to board members. And most recently, a new family moved in, handicapped fella, had a service dog, puts up a fence, and there's a similar fence. One of the regulations is no fences on the corner. There's probably about 6 other fences on the corners that are definitely out of compliance. So now they're going to be raising the dues because they need to cover legal expenses, which were about $4,000 alone last month. And when you try to get information from them about the bills or about the case or any documents, and they've also got a history of not providing documents, what do you do? And am I entitled to see the documents from the attorney so that I can learn and investigate and find out why, we have a lawsuit, so that the community could know, because they keep everything a secret? So am I entitled to see any documents related to the lawsuit as a member of the community? Or is it only the board members that can see what's there?
No, I think there's a full disclosure laws in place, and I think you're entitled to see it. And by the way, the easier way might be to go down to the courthouse, because you can get a copy, you can view a copy of it at the courthouse.
That I've been watching. It hasn't been filed yet by either party, but the legal bills obviously are mounting. So any information they will not share, comment, or provide.
Yeah, well, I doubt you're entitled to a copy of it until they file it.
What about copies of the attorney's invoices?
Well, I think sooner or later you'd be entitled to a copy of those. I'm not sure you're going to be entitled to a copy of that right now.
Well, why would I
during the process?
Why would I be entitled to see copies of invoices for, say, landscaping and lake maintenance, but for another contractor, and basically without insulting an attorney, to me they're just another contractor. I should be able to see their invoices.
Yeah.
Right?
Well, I doubt the law firm is going to give them to you because of client privilege. So the thing to do would be to get an attorney to try to force the homeowners association to give them to you. If they won't, if they don't, and they stonewall you, then your only choice is really to get an attorney to force them to give them to you.
Yeah, I've been down that route already.
So then it's an economic question also of whether you want to spend the money to do that, when sooner or later you'd be probably they would during the annual meeting or budget requests and all of that, you'd probably be entitled to go look at you're entitled to go look at the homeowners association's books. I don't think you can force the law firm because of client privilege to give you copies of the invoice.
So in prior instances, I've asked for copies of bills and I've gotten them. I guess if I ask for the attorney's bills complete to see all the bills that are coming in, I guess if they felt they needed to redact them, they could, but I should still be able to see them.
Yes, sir. Well, give it a shot. Send them a certified letter requesting it, or a time to come inspect the records, one or the other, and then go from there.
All right. Appreciate it. Keep up the good work. You're helping people.
All right, Glenn. Thanks.
Bye.
You're listening to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. The law office is open for about 20 more minutes. You got some pressing legal situation, maybe something that kept you up a little bit last night, can't sleep, would like some information. All you have to do is to call that number, 877-943-9673. That's 877-943-9673. By the way, we're streaming live on Facebook and also on WeBeam TV. WeBeam TV, if you want to go online and see a live stream of the show. Also on Facebook Live on a couple of our pages, the Law Offices of Joseph Pippen page, the Ask an Attorney page, the personal page. I'd like to connect with you on either Facebook or LinkedIn. active on both of those, plus alignable and a few other things. So look us up. Be glad to accept your invite. And then we post some of these questions. We post again on our Facebook pages, the ones that I think would be helpful to others. We post some of those as well. So if you want to connect on Facebook, on LinkedIn, my name is Joseph F. Pippen, and you can be glad to connect with you there. If you would like to call the show, again, we have open lines right now at 877-943-9673. We're going to go to Joe in Jacksonville Beach. Hey, Joe.
Hey, how are you? I just got a general question. That if you get a divorce in the state of Florida and say your wife gets half of your retirement or whatnot, can you go after her 401k also?
Well, what they do in the divorce proceedings, you both are obligated to fill out a financial affidavit form. And then there's usually a division of the assets based on, how the assets are titled and who has what. So, yeah, I would say it's possible that you would, they try to equalize things out. If you've been married over 17 years?
Yes.
Okay, so there's, it's under 7, between 7 and 17, and over 17. There's a kind of a general scheme of things there. So if you've been married for over 17 years, it usually winds up close to, in not all cases, that's why I say usually, for the 50-50 split.
Yeah. So whatever she had on her 401k before we got married, basically she keeps, but anything after between 0 and 17, it would have to be split up.
Well, they're going to look at the assets of both of you. Now, for example, if you both had equal IRAs, you both would just probably keep your own and wouldn't have to share your IRA with each other. They don't make you split them in half when they don't need to. So if they're
as long as we're equal.
Yeah, but let me ask you this: would you and your wife, if you could sit down and agree amongst yourselves as to what would be a fair division of things, would that work?
Oh yeah, yeah.
Well, the thing to do that is for you two to sit down and put all that down on a piece of paper. You're going to certainly make things easier for the attorneys if y'all can agree ahead of time on how to split things up.
Right.
And then y'all can come to some agreements. You don't necessarily have to split the retirement accounts. You can give more or less in other areas.
Right, give something to equal it all out.
Yeah, yes, sir. So it'd be better if y'all sit down and work it out yourself. Actually, yeah, and then, a property settlement agreement document can be drafted, and then that would be part of the divorce proceedings, and you made it easy and cut down your costs considerably.
Right. Well, thank you for the information.
All right, thank you.
Bye-bye.
Let's go to Kent in Jacksonville.
Good morning. I was wondering about a will. If you got, I got a father that's pretty well off, and he's leaving money and stuff for everybody in the family, including grandkids and stuff. I was wondering if I was to die. I know because we've all talked and sat down what we're getting and stuff. But if I was to die before he does, or before the will is put out, for everybody to get their parts, would the money that I'm getting go to my wife or what?
Well, it depends on your father's document, because there's language in your father's document, most likely, that says I give, half of my estate to Joe, and if he's not, to Kent, half of my estate to Kent, and if he's not living, then it would either say normally to your children, or it could be to the other people named in the beneficiary, or it could be your wife, although most people I find don't leave to in-laws because they tend to get remarried and the money could go outside the bloodline. But it's all, the answer to your question totally depends upon what the language is in your father's will.
I can see my kids, they're grown and stuff, but I mean, they're going to get money also, but I don't want to. I don't know if the money I get go back to my brothers or kids, because they're all getting some too, and I don't want to leave my wife high and dry.
Well, you wouldn't be leaving.
She's not the wife. She's not the wife of my children. That was a previous marriage. But we've been married like 17 years now, and I don't want her to leave. You know, I don't want everybody else to get more that they don't, you know.
Well, but yeah, it's not what you want because it's not your money. It's your dad's money. It's what he wants. So let me ask you this.
Mm-hmm.
If you ask your dad to see a copy of his will, would he show it to you?
Oh, yeah, probably.
Well, there you go. Go ask him to see it. And then
ask him to put her in there, right?
Well, if she's not in there.
Yeah, right.
I would tell you a very high percentage of people that leave money to their children do not leave to their in-laws. So,
wait, I mean, you mean like his daughter-in-law, right?
Well, no, your wife.
Which is her daughter, his daughter-in-law, right?
Right.
Is that what you're talking?
Right.
Okay.
And the reason why is because she could easily, you could die, she could get remarried, she could leave everything to her next husband, then the money's totally outside the bloodline.
Mm-hmm.
And your wife's parents, you asked your wife's parents if they left you anything if your wife died. The answer is probably no. They'd probably tell you none of your business, but the answer would probably be no. I mean, that's just the way it is.
Well, I know what her parents are leaving her, but I mean,
yeah, but
I'm
the provision,
thinking we're still together, it'd be all right. But like you're talking about, if I die, would she give some to my kids or something, right?
Yeah,
she could just give it all to her kids.
Yeah, she probably your wife's parents probably left to her, and if she's not living to her children, not you.
Yeah, her kids. Okay. Well, I might have to go down and check out and buy one of them real, buy the wills.
Yeah, go talk. Does your dad like your wife?
Yeah.
Yeah, okay.
He's fine with it. The only person who don't like my wife is my sister.
All right.
All right,
all right, Kent. All right.
Bye.
All right, let's go to Joe in St. Petersburg.
Yeah, thanks for taking my call. I have my mother's 92. We'll be going into assisted living soon, and she owns her own home. Doesn't have payments on it or anything. But I've been told in Florida, if you go into a nursing home or assisted living and you are asking Medicaid to pay, if you go into one of the ones they contract with, are you required to sell your home in Florida or
or
not?
No, your home is an exempt asset. So even if you go in a nursing home, everyone always intends to return to their home, whether they can or not. So the homestead in Florida is kind of a unique situation where the homestead is a non-countable exempt asset. So your mother could go in a nursing home, never sell her home, die. The home could be left to you, exempt from creditors.
Okay. Now, it is true, though, she would have to deplete her savings account if she has anything. If you're asking Medicaid to pay.
Nope, that's not actually true either. We have a full-time Medicaid attorney on our staff who's actually written a couple of books on this, on VA planning and Medicaid planning. And there's a way that he would shift assets around to make them non-countable, protecting the estate to be able to use for her benefit and still qualify for Medicaid. He does this every day. He's done in thousands of cases, and this is possible to plan all this out to protect the estate, move more assets into non-countable categories, protecting them for her benefit, and then having them left over when she passes away for the family and still qualify for Medicaid.
Okay.
If you want to contact me, I can put you in touch with, his name is John Frazier. He's on our staff. That's all he does is Medicaid planning. He can talk you through some of the planning options.
Okay, good.
All right, Joe?
Thank you, buddy.
Thank you. Let's go to Byron in Orlando.
Yes. Hello.
Yes.
My name is Byron. I had a question. My mom had a probate case.
Mm-hmm.
So she went and retained a lawyer. The lawyer, I guess she gave a $2,500 retainer fee.
Mm-hmm.
The lawyer gave her terms of engagement agreement, and I guess later on in the contract it says the retainer and the hourly charge fee. I guess the retainer is non-refundable, but in the terms of engagement agreement, which he only gave her that portion of the contract, he didn't give her the entire contract. That portion said a deposit was refundable if anything was left over from that $2,500 retainer fee. So the question is, my mom would like to get that retainer fee back because the lawyer never really actually, he initiated a letter to the court where he was going to take on the case, but he never actually really worked on the case.
So how long ago did all this happen?
We signed the contract like in January, but she terminated him in like March 8th. So
what was the reason for the termination?
Because he wasn't really working on the probate case because she was actively trying to seek her estate in my grandmother's house, her mother's house, but he was more interested in an injury claim that a wrongful death claim that it was the other siblings was trying to do. So he wasn't actively pursuing the.
Well, has a demand letter, like a certified mail letter, been demanded to get the refund back?
Yeah, we sent the demand letter, which he replied with a letter saying that basically her retainer was non-refundable.
All right. Well, the Florida Bar has a mediation program on fee disputes.
Mm-hmm.
So you might, it's not a complaint against the attorney, but there is a way to request a mediation for a fee dispute. You might contact the Florida Bar and discuss that with them and see if you want to take that step.
Okay.
And the only reason I say that is because it seems like to me in your question, the early part of the question, there was some conflicting information about the retainer fee.
Yeah.
Yeah, so you might point that out in the second letter to the attorney.
Mm-hmm.
That, due to the conflicting information in the retainer agreement, you would like to settle it with him, but you understand there's a mediation program that you might seek if we can't come to an agreement with him.
Okay.
All right?
Okay.
All right. Thanks for calling.
Thanks. Bye.
Let's go. Let's give out the numbers. We have about 8 more minutes or so. If you'd like to call the show, you have a toll-free number, 877-943-9673. That's 877-943-9673. If you tuned in late, would like to watch or see the whole show, you can go to WeBeam TV and catch out the whole show. Plus, they have a whole host of programs from the past there you could go and watch and see and learn. Let's go to Mike in Pinellas Park.
Hello. Good morning.
Good morning.
I have an identification issue. I moved here from California last year, and I went to the DMV to get, my license changed and all that, and took the birth certificate. And that's where the trouble starts, because my birth name is different than the name I'm using now, because my mother remarried when I was, 2, 3 years old. I don't know. And I have no paperwork on this, and they want some sort of paperwork connecting me with, my name now to my birth name.
Well, can you order a birth certificate from the Bureau of Vital Statistics in the county you were born?
I have my original birth certificate, but it's in my original name.
Okay, how did your name change?
By my mom remarrying.
So there was a formal name change proceeding when your mother remarried?
I don't know.
No, normally that doesn't happen.
Mm.
So what name was on your driver's license? The name that's on the original birth certificate?
Right.
Your name doesn't change when your mother remarries unless there's a formal name change to the court. So you are who you are on your birth certificate, absent any formal change to the court.
Oh boy! Well, what do I do?
And you said
now?
you had your birth certificate, so I don't see what the issue is.
Well, I took it in, and they just said, "Hey, this isn't your name. This isn't."
Well, why did they tell you it wasn't your name, though? What did they have in front of them that suggested it wasn't?
Well, they have my driver's license
with your name on your birth that has your birth certificate.
that I've got with my stepfather's name. Because when I first got my license, it was 69. It was 1969, and I remember.
Hold on. If your name changed when your mother married and your name has your stepfather's name, and then for that to have been legal, there would have been a court process, which means there is a court order somewhere that in the county that took place that has why it changed, and with a court order signed by a judge that it changed upon your mother's remarriage. They did a name change for you. They did a name change procedure, and in the county all that took place, there would be a proceeding.
I was just wondering though if something could happen, like she remarries and just says, "Hey, okay, all the kids are named this. Start using this name," and no paperwork, and then I'm stuck.
Well, if there's no formal name, your name goes back to what's name on the birth certificate. So I don't know why the DMV wouldn't accept that.
I know, and then my Social Security is in my stepfather's name. So
okay, well, there had to be.
It really makes.
No, there had to be a formal name change. So go back to the county where she got married. And
oh boy, then now how would I find that? I don't even know where she was.
You don't know where she was remarried?
No.
You could contact Social Security and see the date of the change on your Social Security card. And then at least you would know the date. And then maybe you can figure out where she was on that during that time period.
Okay.
All right.
I'll try that.
Thank you, Mike. All right.
Bye-bye.
All right, let's go to Jenny in Tampa. Hey, Jenny.
Hello.
Hi. What can we do for you?
Yeah, the question is, my ex-husband is in the nursing home now, but there was a guardian, a lady that managed it.
Mm-hmm.
All his finances.
He was declared incompetent and there was a guardian appointed?
No, it's just a lady managing it.
Like with a power of attorney?
Yes.
Okay. We have about a minute, so I don't know. I just want to give you a little heads up. Can
my son take over of doing all those?
Well, is your husband mentally able to sign a new power of attorney?
Yeah, he's mentally able. He's just bodily.
Well, yeah, your husband can sign a power of attorney and give your son the power to do what this current lady is doing. So yes.
Yes, because she called. She put him next to kin and everything.
Mm-hmm.
But besides that, nothing else and stuff. But she'll call and say, "Hey, your dad is in the nursing home now."
Now, your husband can revoke the present power of attorney and sign a new one.
All right.
All right?
Okay. All right. Thank you.
Thank you.
Bye-bye.
All right. You've been listening to Ask an Attorney all about Florida law. If you'd like to contact us for the free estate planning poster sheet, or if you'd like to contact us for an appointment to discuss your estate plan or any other legal issue, you can request the poster sheet or make the appointment at this number, 1-800-226-3529. That's 1-800-226-3529. Go to extension 200. If you want the poster sheet, I just need your name and address. If you want to do that this weekend, you can just call and leave a message. 1-800-226-3529. If you want to send me an email with your name and address for the poster sheet, or even requesting an appointment, I can send it to the person that would sets up appointments. It would be Joe, Joe, at attypip.com. That's Joe, Joe, at attypip.com. If you'd like me to text me the information, you can text your name and address to Joe, Joe. Oh, let me see. Text to 727-667-3967. That's 727-667-3967. Hey, the show is broadcast on whatever station you're listening on every Saturday morning at 8 o'clock. They also replay it on 5 p.m. on Sundays on 579.10. And the Sun City Center community station also now, understand, replays it on Sunday at 5. You have a great, great weekend. So long.